Good morning, everyone.
Good morning.
Nour Hineidi here, the Deputy Registrar. I'm going to let Ms. Al-Shahi read out the opening statement. Thank you.
Thank you.
Yeah. We are here for a hearing in the matter of CFI-023-2019 before Deputy Registrar Nour Hineidi. The claimant is represented by Abdul Hakim bin Hur's advocates and legal consultants. Lead counsel is Abdul Hakim bin Hur's. The defendant is not present.
Thank you very much. Mr. bin Hur, so basically we can see that an immediate judgment application was filed by your client in this matter, but there's some things that we need to do in order to get this application ready to be heard. And this is the purpose of the hearing today.
Yeah.
So a few things. First of all, the application was not filed in the correct form. If I just pull up the relevant page, you'll see that something was filed on the, just bear with me please, on the 5th of February. It's called Judgment on Non-Parties. So I'll need to direct please that the form that was filed, being 127940, I'm going to grant you leave to amend the form so that the form is a Part 23 form. So you don't need to refile it, you just need to amend the form, but you'll need to reserve it.
Okay.
So that will need to be reserved pretty soon. So I'm granting you leave to amend it to a Part 23 because that's the correct form. So the document, the correct document is not the judgment on non-parties, it's just Part 23 application for immediate judgment. And it attracts a fee of $300 US. So the registry will sort out the invoice in that regard. Now, when you do that, after you amend the form, you'll need to file an affidavit in support of your application. And I'll need to see some submissions in evidence setting out reasons why you're applying for immediate judgment. And based on what I can see from the file, it's simply that the other side has not engaged in the matter. They've not filed a defense in time. They've not complied with the requisite timelines in the DIFC court rules. So it'll be a pretty straightforward affidavit in support of your application, but I will need to see one, and it will need to be exhibited, and it will need to refer to parts of the DIFC court rules.
Sure.
So that will be the second component. I would also suggest that in the alternative, for example, even if the judge is not minded to grant the immediate judgment application, you'll need to have some other submissions on the substantive case. So the judge, for example, should grant the immediate judgment application on the basis that substance fails for these reasons, for example. So I would not just limit my submissions to the procedural submissions that I've just spoken about now. So when you make the amendment, please, and when you file the affidavit in support, you will then need to reserve all of the documents relevant to the immediate judgment application and to the claim. For example, also the particulars of claim, etc. So you'll need to reserve everything onto the other side. And I can see that you filed various certificates of service to say that you have served by way of email. But if you look at rule under Chapter 9 of the RTC, so Part 9 rules, you'll see that to serve by way of email, you have to fulfill some requirements. One of them being, for example, permission from the court, or another type of requirement, which is essentially that you've had contact with the defendant through this email address. The contact has been recent and they have consented to be served by way of email. And the way that you would prove that is through an affidavit of service. Now, I can't see any affidavit of service on the system, and I can't see that any permission was granted by the court for you to serve by way of email. So you can either apply to serve by way of email, and you do that through an application for alternative service, or otherwise you will serve through the usual means of service by courier. Or otherwise, if you wish to serve by email and you're sure that you can serve by email, then I'd like to see an affidavit in support of service. So an affidavit which says, I can serve by email for these reasons, I have complied with IDC 9 for these reasons, and then we will be satisfied that service has been properly effected.
Sure.
So that's a few of the things that we need to do. Now, I've had a look through the draft order that was submitted by you on the 16th of April, and the draft order says on the second page, and I'll just read it out for you. Within 14 days, the order, within 14 days of the order, the defendants, that's fine, shall join, and you've also mentioned the personal guarantor, Ali Ahmed.
Yes.
So the personal guarantor is not a party to these proceedings. If you wish to add him as a party, you've got to file an application to add him as a party to the proceedings. And you'd have to particularize your claim to include your relief sought as against the personal guarantor. But you can't include the personal guarantor's name in any draft order. You can't include him in anything if he's not a party. He would be a third party, and the only way a third party would be compelled to do anything is to disclose certain documents or to hold money on account, but they're not compelled to pay. So that's not a power that the court has. So you've got to join them in into the proceedings and give them a chance to respond. So obviously the personal guarantor in this situation has no idea of the proceedings. It doesn't make sense to obviously issue an order against him when he has not had the chance to respond or fight back. So you can you've got two options. You either delete all references to the personal guarantor and you focus only on the defendant, which is mentioned in your claim form, being Treasure Line General Trading, represented by Muhammad Usman, Amin Muhammad, or you join the personal guarantor as a second defendant.
Yeah.
Correct, yeah. So a few things to do before this is ready to be heard.
Sure.
Now, I would strongly suggest, we have seen, and I don't usually mention this to parties or to counsel, but we've seen lots of interaction on this particular case by a person by the name of, who goes by the name of Rima, who doesn't seem to, and she appeared before me at a different hearing, and I was quite staggered as to the level of her competency. I do hope that from today onwards, the file will be handled by yourself or someone else who is very competent within your firm to deal with these. And a gentle reminder that only Part 2 registered practitioners can appear at hearings. So I don't expect to see Ms. Rima at any other hearings from here on in, on the basis that I can't see that she's a legal practitioner, and even if she was, I would not qualify her as a Part 2 registered practitioner. So that's just a little note, I think, to bear in mind.
Yeah, noted.
Thank you very much. Do you have any questions? I've been doing a lot of the talking and haven't given you a chance to ask any questions.
No, it's good. At least, this is very clear direction now. So
excellent.
Just one question, if you don't mind,
Of course.
Nour. Okay, in regard to Part 23, we are going to do this today or tomorrow. How many days we have in order to submit the affidavit? From the date we corrected to Part 23 form.
How many days have you got to submit the new Part 23?
No, the 23 we will do it. I think we can do it anytime, correct?
Okay. Yes, you can do it anytime, correct, yes.
But then we have to also, we have to submit affidavit. And how many days from the date we corrected to Part 23, we have to submit the other documentation?
The evidence. Yes, so usually you've got to do it all at the same time.
Usually same time.
Everything is done at the same time, correct? Yeah. So
Okay,
everything appears part and parcel. So you make a Part 23 application,
excellent.
you
We
file
got this one.
everything
Yeah.
correct. Correct.
Very good. This is one. And the second question, from today is the hearing for direction. So do we have to do this within a limited period or it is open-ended?
Yes, so this is the other thing. It's not open-ended because your claim has to continue progressing. So I'm going to give
Absolutely.
you 28 days from today's date
Excellent.
to make the relevant amendments, and I'll issue an order to that effect.
That's
Mr. Shahi, if
excellent.
you don't mind preparing. Yeah. So 28 days, and then once you have made the relevant updates, you'll have 14 days from that date to serve.
Sure.
And then the other side will have a chance to respond to the servers in line with the IDC. And if they respond, then the procedural timeline will become very different. If they don't respond, then it goes immediately to an immediate judgment
Excellent.
application hearing, yeah, which could be determined on the papers or in person. So it depends on what the judge wants to do with it.
Very good. So the permission for notification, because you know, both have left the country. The only
Right.
thing we have is their email. I think the
Okay.
permission, we can submit it any time to seek the court permission that to serve them via email because we have their email. And one of them, in fact, he updated us with his email, with current email as well.
Very good. So I think what you need to do is in the affidavit of service, if you wish to still serve and you're happy that you can fulfill the service requirements under Part 9 of serving by way of email, then I would do an affidavit on the side to say, by the way, he even gave us his updated email address. This means consent in
Yeah.
our mind, and then you put the relevant submissions forward, and then we can decide whether the service was properly affected. But what I would do, very importantly, is just to ensure that service is completely perfect, because if it's not, we'll keep turning you back and saying, you know, you need to let them know, you need to serve properly, etc. So from the date that so you'll have 14 days to serve, so you've got to make the immediate judgment application pretty quickly after you file the Part 23. Yeah.
We will do that. Well, very clear, Nour. Thank you so much. This is
My
very
pleasure.
clear direction.
Thank you so much. Thank you.
Yeah.
Wonderful. Thank you very much. Have a nice day.
Thank you. Same to you, and same thing to Mate as well.
Thank you. Bye-bye.
Bye.